what I want to do, and I'll try to keep it to about 10 minutes or so total. I'm going to start by talking about the two principal constitutional provisions that are at issue in the case, the Fourth Amendment and the Sixth Amendment to the Constitution. I'm going to then talk about them in the context of what was done by the FBI and by the United States in prosecuting this case. And then, should I continue in talking about what happened with the court decisions, or did you want to take? Okay, so I'll go through all three of those things. The thing that's very troubling about this case is that regardless of the guilt or innocence of the Imam and Mr. Hussein, and certainly reading the paper, certainly following it, it's very hard to believe it is anything other than a tragic miscarriage of justice. But aside from that, if you're going to believe in the American justice system, which is, well, whether you believe in it or not is another matter, but the question is, but the basic thing about the American justice system, or any justice system, is you have to believe that it's a fair process, that the process, that at least if you play by the rules, you can at least go through it, and at least the rules will be observed, and you get to a just result. And the way our rules are set up, we have a constitution which guarantees certain fundamental rights. It was adopted in 1789, just shortly after the Constitution. We had a Bill of Rights with the idea of protecting certain rights including criminal defendants, to make sure that they got a fair trial. Two of those principal rights were the Fourth Amendment, the right that people are to be guaranteed to be secure against unreasonable searches and seizures, and the Sixth Amendment, the right to a fair trial, or specifically, in our case, the right to confront witnesses against you. That if you're going to be held to account in a criminal court, and you're going to be on trial, and you may go to jail or may be executed, that you have a right to confront those people who are accusing you. And these two rights were both violated in this case. In the Fourth Amendment case, there was a famous case in the 1960s that said, it established what's called an exclusionary rule. Excuse me. Basically, if the evidence that is gotten against you has been gotten as the result of an illegal search and seizure, it cannot be used. It is excluded from use. In the best words of the, don't ask me which judge it was. I think it was Brennan, but I could be wrong. It's the fruit of the poisonous tree, and it will be excluded. It will not be allowed in evidence. So, and the idea was that you wanted to prevent, if you didn't exclude evidence that was illegally gotten, you would basically be giving police a license to get evidence by unreasonable methods, and you wanted to make sure that didn't happen. You don't want police knocking down the doors to find evidence. They've got this without a warrant. If the police don't have a warrant and they search the house, you can't use the evidence, because that's a way to make sure that you keep the system honest, to keep the whole process to be a fair process. The second thing I want to talk is the Sixth Amendment. Is the right to a fair trial, and one of the rights in a fair trial is the right to have all evidence that may be in the possession of the law enforcement authorities. You have a right under a Supreme Court case called Brady, and there's a thing called the Brady Rule, to have the police or the law enforcement or the FBI, or the prosecutor, they must disclose any evidence, any exculpatory evidence, any evidence that will tend to prove that you're innocent. Because if the police are investigating and they do a whole investigation and they find out a whole bunch of things, they find out far more than you would know, or that your investigator can find out, or your defense attorney can find out, and they know you're actually innocent, but they don't want to. But of course, they're in the business of prosecuting the case, and maybe they're not going to, and maybe they're more interested in getting a conviction than they are in giving you a fair trial. But if they have evidence and it's demanded, they must turn it over to the defense counsel. Now, in New York, in state court, that's actually into the statute now in the criminal procedure law. But in federal court, it's still true. It's still the law. Now, what is exculpatory evidence? Now, what is, for example, is evidence what evidence proves that somebody is innocent, and what evidence may not prove someone is innocent, but is still something that you want to have access to. Supposing, for example, that the police are aware of a conversation that the defendant had with the informant, and the defendant said some things that aren't particularly good for the defendant. But in the course of that whole thing, in that tape of that conversation, the informant is shown to be a very bad person. and the informant is going to testify at trial. So the prosecutor could say, well, it's not exculpatory because it doesn't show that the defendant is innocent, so therefore we don't have to give it to you. But on the other hand, he could argue that from the defense perspective, wait a minute, if I had access to that conversation and the confidential informant takes the witness stand, I can use the evidence in that tape. I can ask him questions about that, show him to be a liar, show him to be somebody who you shouldn't trust, and that's going to help me get off. So even though the evidence in that tape doesn't help my case, doesn't prove me innocent, it still will help my defense. So the question is are you entitled to evidence which is not just, quote, exculpatory to prove your innocence, but just evidence that will help your defense? Now those are the basic standards, and I'm not going to answer that question. That gets into some hair splitting in case law, which is beyond the scope of a short presentation. But I want you to be at least aware of that. Because now what happens in this case is that the first thing that we're confronted with is that the National Security Administration, or agency, has been engaging for a number of years in illegal, we would argue it's illegal, but certainly warrantless surveillance. This is a question, the Civil Liberties Union has a case, it's pending, was argued before the Sixth Circuit Court of Appeals last week, challenging the surveillance program, saying that that warrantless surveillance is illegal. We have reason to suspect that there was plenty of warrantless surveillance of going on in this case, that the imam and Mr. Hussein were the subject of such surveillance. If so, what happens with that surveillance? Should it be used? To what extent is the criminal case that was brought against them based on that surveillance? We don't know the answer to that question. One of the things that their lawyers did, Terry Kinlan and I think it was Terry Kinlan, I don't think Kevin did one, or just...
He joined it.
He joined it, okay. Kevin Louis Brandt represented Mr. Hussein, Terry Kinlan represented the Imam Aref, was they made a motion early on to say, this case has got to be dismissed. It's based on illegal surveillance. It's, any evidence that is the fruit of the poison tree, it's therefore you've got to throw the case out. They made that motion early on in January of 2006. They were unsuccessful. The government then moved to say, wait a minute, we have some other information here which we think is classified information, and we want. And they filed this information ex parte. That means without the knowledge of the other side, only viewing it with the judge. Said this evidence shouldn't be seen. We don't want it. And in fact, the judge McAvoy said, yes, it shouldn't be seen. Now, Judge, and what happened with, but he did issue a protective order saying there is this evidence and it should, and I'm saying it shouldn't be seen. And then there's another question. Well, okay, if that evidence shouldn't be seen, can it be used at all, or can you use anything related to that? And if you can use it, to what extent does that involve the Sixth Amendment? The Sixth Amendment being the right to confront the witnesses. If you're going to have evidence that may be used, can you see it to at least cross-examine it? Or is this evidence subject to a protective order? And what happened was that there was a motion made before the district court to see if we could get access to that. District court said no. District court said no. This evidence in question is basically, there's a national security interest. The security interest outweighs the interest of the public in access, and proceeds to quote a whole bunch of cases, basically involving the news media, basically involved cases where the public was denied access to classified information because of the interest in national security. And the problem with that is that there's a different standard here, because we're not talking about public right to know versus national security. We're talking about an innocent man going to jail for the rest of his life versus national security. And that raises a whole different level of balancing, because when you're talking about a criminal trial where somebody is, maybe falsely accused, they have certain rights, and those rights and were not respected by the court. There was then a motion that the matter was taken up to the Second Circuit Court of Appeals. The Second Circuit Court of Appeals had rendered a very interesting decision. The Second Circuit Court of Appeals was asked by a procedure called a writ of mandamus, which I'll talk about briefly in a second. But they were asked to do a few things. They were asked to, one, the same relief that was asked of the district court. They were asked to say, dismiss the evidence is illegal, dismissed the case, and they were also asked to grant access to the information. They asked that the defendants be granted access to the information so they could see what it was, so they could confront it, so they could address the issue at trial. And the Circuit Court of Appeals basically said, they said they had no jurisdiction against the United States. Now, how does the court not have jurisdiction against the United States? This is the Second Circuit Court of Appeals, one level below the Supreme Court, and they say they don't have jurisdiction to entertain a claim. Well, the reason they don't have jurisdiction, according to the court, is because they're an appellate court, and they only have jurisdiction to hear appeals from decisions that were already made below, made by a district court. And the district court hadn't actually decided questions with respect to the United States. They only decided questions with respect to how they were going to conduct the trial. Fine distinction. Because with the district court, and the district court, of course, had decided, well, you can't, you say, we're going to proceed with this, you're not going to have act, we're not going to dismiss it, so why can't you appeal that decision? Well, you can't appeal that decision because the writ of mandamus, and I said I would explain it. The writ of mandamus is basically an order to direct a governmental official to do something which you say they have a legal obligation to do. If you go to the town and you apply for a building permit, and the town says we're not giving you a building permit, you do a writ of mandamus. In New York, it's also called an Article 7. It's one of the types of Article 78 proceedings, which some of you may have heard of. But it's
careful. We're not trying to make lawyers out of it.
Yeah,
I apologize. I only use the word writ of mandamus because that was one of the things that was involved in this appellate court's decision, and because what the appellate court says is that, and this is the only point that's important, and I apologize if I made it too complicated, is they said we're not going to hear any of the issues involved in this trial in the context of this writ of mandamus, as it was called. We're only going to hear it in the context of an appeal. What does that mean? It means that the Court of Appeals will not entertain they will not hear the issues at this time unless there's a trial and a conviction. So if they heard it and decided those legal issues then, and decided, yes, there is a question of illegal surveillance, yes, you don't have a right to keep this information away. This information, which the district court said, we can't separate the classified information from the non-classified, so we're not going to let the defense counsel have any of it. If they decided those issues then, there wouldn't have been a trial. But instead, we had to go through the whole trial. We had to go through several weeks of testimony. We had to have the confidential informant be on the stand, without all the access to the information that we would have wanted to cross-examine him. I say we, I wasn't a member of the defense, but we meaning the people who were defending it, and have to go through it. And then if he was acquitted, that would have been the end of it, of course. But unfortunately, they were both convicted. So now, 6 months later, after the Imam and Hassan go to jail for a year or so, waiting the decision of the appellate court, now the issues will finally be decided, because the appellate court, hanging on this technicality between the difference between a writ of mandamus and a direct appeal, decided not to decide the issue and instead left the matter for trial. And that's where we are. So we have these issues left with the Sixth Amendment and the Fourth Amendment. Whether or not there was evidence that was illegal that was used to get a conviction. We had the question of whether or not whether or not Aref and Hassan were denied their right to confront their accuser, to confront this confidential informant, and whether that issue, and whether or not and if they were not given their rights, then of course we do have an appealable issue, but we have to go through the whole thing of a trial and an appeal and being incarcerated in the meantime until we can get these issues finally addressed by the appellate court.
Thank you.